Child custody mediation can feel overwhelming, especially if you don't know what to expect. In this video, I'll walk you through the process so you can go in prepared. Hi, my name is Schwartz. I am from Peaceful Separation and Divorce. If you are in the middle of a child custody case, my child custody playlist can help you be prepared. Why choose child custody mediation? Child custody mediation is a process where you and the other parent will own the result, will structure and will craft the custodial schedule, and will, at the end of the process, not have to deal with a judge. The two of you, with my assistance, will arrive at an appropriate result. Child custody mediation is certainly preferred over going to court. Court is inherently expensive, and it's inherently a much slower process than mediation. Judges will see you for 2 or 3 hours at a time, generally one time, and you'll have no opportunity for the court to really get to know you or to know your needs or the needs of your child. In mediation, you'll spend several sessions with the mediator, and we'll be able to craft a result that makes sense for both of you. Is child custody mediation mandatory? In most counties in Pennsylvania, it is not. Montgomery County is one county which will compel you to go to one mediation session, but no more. The other counties in the southeastern Pennsylvania area do not require custody mediation. Who participates in mediation? Various offices conduct their mediations differently. In my office, there's only 3 people in a virtual room: the 2 parties, the parents, and myself. Lawyers don't come into the room. Third parties generally don't come into the room. This is a confidential, private process between 2 parents and the mediator. Is there ever a situation where children are in the room? It's difficult to answer whether there's ever a situation when children are in the room. I can say to you that in my 40 years of practice, I've never had a child participate in custody mediation in my office. Here's what to expect during the mediation process. It's helpful if each parent can begin the process with being able to state what their needs and desires are and what they think is in the best interest of their child. From that, we'll talk about a specific schedule that will include a schedule during the time that there is school in session if the child is that age, maybe a different custody schedule in the summer. It'll include a schedule during holidays and during vacations. What's the typical timeline and number of mediation sessions? I think if I lined up 100 mediation partners against the wall and asked them how long or how many sessions they had with me, I think the average is probably in the range of 3 to 5 sessions. Some can be less because some people come in with a roadmap of their custody schedule, and I'm doing nothing more than writing it up. And it can be more than 5. People decide their custody schedule and their custody needs in different periods of time and different numbers of sessions. What topics are discussed in custody mediation? We're going to be discussing and attempting to arrive at a custody schedule. We're going to want to know what the needs of a child is. If a child is in school, there may be a choice of school decision to be made for the following year or 2 years down the road. Some children have special needs, and that brings in other topics which need to be discussed and arrived at in deciding perhaps what school is the best or what custodial schedule is the best. What is the difference between physical and legal custody? Legal custody has to do with which parent makes major decisions for the child. In most cases, legal custody is shared, meaning parents have an obligation to consult with one another before making a major decision regarding the child, which generally is religion, education, and healthcare concern. Physical custody is the actual schedule of when a child stays with each parent, and it can be equal. It can be where one parent has more days during the week than the other. It can be a situation where a parent has more time in the summer when the child's not in school. There's just a host of possible solutions. That's something that would be discussed during custody mediation. What is the mediator's role? My role is to act as a neutral party. I do not give legal advice. I will not tell either of you what to do or what is best for you. I will set parameters on what is customary in custody if the parties want that, but my role is as a neutral party to assist you in making a resolution of your matter. Mediator can't enforce the decision, meaning that if we arrive at a custody schedule and we put it in writing and you sign it, but one party doesn't follow it or wants to change it, the custody mediator cannot get involved in that. That's something only a court can do. However, if there is a situation where a custody schedule is not being followed, a party wants a change, they can certainly return to their mediator and work that out in front of their mediator. What happens after mediation? After mediation is over, I will prepare the appropriate agreement for you. You will both review it, we'll make any necessary changes, and then you'll sign it. Most times a custody agreement that's signed is filed as an order of court. The mediator does not do that for you. You'll either need to do that yourself or hire an attorney just for the task of filing the document with them. What if no agreement is reached? If an agreement can't be reached, most parties will end up in court before a judge. And I think that's the hammer. I think that's what a lot of people want to avoid. They want to avoid going to court. And I think it helps parties be more reasonable and more willing to enter into an agreement and not go through the process of litigation. What are the pros and cons of mediation? The pros of mediation certainly are it is faster than proceeding through court litigation. Mediation can be done in 4 months, 5 months. The average custody case is going to be somewhere between 1 and 2 years to go through the court. It's also far less expensive to mediate a dispute than to try a dispute in front of a judge. The downside is parties have to be able to make a decision, and sometimes parties have difficulty doing that. So you need to be prepared to be flexible, to hear the other side's point of view, and to come into the process with the idea that the two of you are going to craft an agreement that may not be exactly what either of you wanted coming in, but works for both of you and for your child.